Please, Your Lordship. I have prayer for listing of two cases, my lord.
Listing due to the court master, it
My
will
lord,
be next week only.
Next week, my lord, in the last week of, even after thereafter.
There will be, but this 1 or 2 days we are in
My lord.
some
May I
difficulty
please,
for listing.
Yes.
Yes,
I am praying for upgrading item number 21.
we can't say because we'll be rising early. There is a
That's a
single bench.
medical emergency.
Item number
21. IA.
21. Okay, we'll try to.
Bless.
My lord, I'm praying for listing of a case next Thursday, my lord, 23rd.
Not on Thursday, Wednesday or Friday.
25th then.
Friday.
Public.
For motion, item 1.
My lordship, in this case, we have,
Yes.
my lordship, in this case, my petitioners have visited the Kokrojhar, but they have not informed whether he is there or not, my lordship. Whether he is alive or dead, they are anxious, they have not informed. And I would like to bring certain things on record. So kindly, one affidavit I want to file, my lordship. Kindly that time may be given, my lordship. I have bring certain things because we have given the copy of the order to them, but they have not given any receipt of that copy. They don't even allow. So on the same day, we have given another copy by post, registered post to them, my lordship, and that they have received. And neither SP is informing that where.
I'll file an affidavit. Mr. Payan, please look into it because otherwise we'll have to drop contempt if despite the order is not being allowed to meet.
Like
Item 1,
item 1.
we may be compelled to drop contempt. On the both sides represented on the prayer made by Mr. T.K. Dale and counsel for the petitioner. Time is granted to file an to the time is granted to file an affidavit. Full stop. List in the next week as and when the affidavit is filed.
Deeply obliged.
Item 2.
Yes, Mr. Chakravarti.
Lordship, I have received the instruction.
Just tell us what is there.
Lordship, we have received, the BSF has received one Doijan Bibi by name, but she is the wife of Abdul Munnaf, not Abdul Razak. Lordship, find at the serial,
Just now.
plague mark 1, Lordship.
Just.
Wife of Abdul Munnaf.
Not Dojan.
No, a Doijan Bibi.
But they're not
Abdul Razak.
Abdul wife, no.
As per list provided by the state, the police. Nothing's wrong.
Okay, reference number.
Reference number, মানে তুমি যে বলবো এই FIP number আছে, FIP number. FIP number DAS 024722025.
Yes, Mr. Chakravarti.
Lordship, we have received one Doijan Bibi, but he is the wife of Abdul Munnaf. Lordship, will find at the flag mark 1, Lordship. Serial number 27. From the border police. And she has been pushed back, Lordship, as per the instruction received.
There is reference to case number.
The case number,
There's the same person or different person.
80 number.
Can you obtain instruction and come after some time? After 5 or 10 minutes after speaking to them, the people who have instructed you,
My lord.
is this person, Abdul Razak,
Yes, my lord. This is the
has an alias of,
Alias naam aise nahi.
I have to find out, my lord. I have to find out.
come back after some time.
Yes,
Just wait for some time.
my lord, my lord. Good Manna, please. I'll do it.
Manna.
After some time.
Item 3,
May I please, as your lordship? My lord, pursuant to my lordship's last order, my lord, we have been allowed by the, my lord, holding camp to visit. And we have also obtained the wakalatnama also, my lord.
This
Now-
can be closed then.
My lord,
This can be closed then.
my lord, may I pray, my lord? My lord, as the husband of the petitioner, my lord, who was on bail pursuant to an order of the Honorable Apex Court, my lord. And thereafter, my lord, I have been released by the concerned superintendent of police also with a specific terms and conditions. My lord, as I am obeying the terms and conditions, my lord, it has not been violated. My lord, so therefore, now keeping me on holding camp, my lord, with my all limited knowledge, what I respectfully beg to submit, my lord, is that. my lord,
Because because the process of deportation must take place pursuant to the opinion.
My lord, but the deportation, my lord, till the deportation is made, or if it is possible, my lord, then I will be in the holding camp, my lord. And there is no any such direction that those persons should be kept on in a holding camp, my lord.
My lord, we have filed an affidavit today, my lord, in this case.
In this case,
I have served a copy to my lord and friend
And,
also.
my lord, it may come up along with the affidavit.
Wednesday, list
Wow.
on 23, 7/2025, along with the affidavit stated to have been filed by the state.
item 4,
Lord, this is also in a similar footing, my lord. We have been allowed to, my lord, meet and, my lord, signature in the wakalatnama has also been obtained. My lord. Lord,
This matter be closed or you want to keep it pending?
Lord can keep the same pending, and in the meantime, we'll file an IA, my lord. I am preparing an IA also in both the cases, my lord, for seeking my lordship's interference for the release of the lord detainee, my lord.
Okay. You intend to rely on the same affidavit here
My
also?
lord, I'm sorry, my lord, the in item number 3, no affidavit is filed. Item number 4, we have filed, my lord. Both the affidavit will be same.
Same.
Stand is same. We are relying on the my lord,
Stand the same, but the facts may be different.
facts are to some extent different, but I'm relying on
There is
this.
this last order, make it in item number 4.
4.
Huh? And in item 3, you say
Yes.
both sides are represented. Mr. J. Payang, and standing counsel for the FT matters, has submitted that an affidavit has been filed in connection with WPC 3487 of 2025 today. Today, right?
Yes,
My
my lord.
Today, and state would be relying on the said affidavit in this writ petition also. Full stop. Let a copy thereof be provided to Mr. A.R. Bhuyan and counsel for the petitioner. Next para, list on 23/7/2025.
We have already provided.
But we have received a soft copy, my lord. Obliged, highly obliged.
You see, a copy of the affidavit has been provided instead of that, huh? Okay.
Obliged.
Lordship has directed the election commission to have this.
Yes, yes.
Instruction. Lordship, I have obtained the instruction. I have
Oh, good.
produced a manual. Okay, sir. Lordship, in this case, as Lordship has asked for some specific instruction as regards the language of electoral rolls, Lordship, in which in Assam it is published. If your Lordship come to this volume in page number 294, there is an annexure, Lordship.
William, page number
I
two.
have flag marked it.
Yes, yes,
In
two
page number
ninety-four.
294.
Yes.
In Assam, your Lordship, point number 4 is Assam.
16.
Lord.
Ah.
In the first 15 district, Lordship, in this district, the electoral rolls are published in Bengali language, Lordship.
Yes.
In number 16, Haflogra ST, here the electoral roll is published in English, and all other assembly constituencies, your Lordship, the
It's in
electoral is published in
Assamese.
Assamese.
Thank you. We
Lordship,
really
and
needed this.
yes, Lordship, and as respect to this provision, if your Lordship comes to page number 50,
50.
50,
Yes.
that is point 9.4 on the left-hand side, Lordship.
9 point.
9.4, language of electoral rolls.
Yes.
It is mentioned there, Lordship, that Rule 4 of the Registration of Electoral Rules 1960 provides that electoral roll shall be prepared in such language or languages as the election
Election Commission,
commission.
yes, that is there in the act also.
That is there, sir, Lordship. And why it is prepared in multiple languages? Sometimes in certain states, your Lordship, that it is published in 2 languages also. That is also been mentioned why, and your Lordship, it is.
Okay. But thank you for your effort
Lordship,
to give us a
that is my duty, your Lordship.
photocopy and give it. It's really helpful because this is an issue which always intrigued us, but we did not have an answer.
Lordship, it is a very elaborately written
Ah.
in a very well mannered. Your Lordship can anywhere refer to it anytime. Your Lordship,
Thank you.
obliged.
We appreciate your effort.
I please, your Lordship. My Lord, as per earlier order, my Lord, a matter has been, my Lord, listed for consideration of my Lord, bail, my Lord. In fact, my Lord, LCR has received my Lord, my submission before your Lordship, my Lord. My Lord, petitioner, my Lord, may be allowed to go on bail.
Shows a document, best document to connect you to your parents,
My-
not the voters list. Except for voters list, what document you have to connect you to your projected parents?
My Lord, your Lordship kindly see land document. Voter list, my Lord, in fact, my Lord, 70 voter list, his parents, my Lord, name are inserted, my Lord. Page,
Is your name appearing with your parents?
yes, my Lord. My Lord, your Lordship kindly see page.
Which page is the opinion?
Page 90, my Lord, my name is, my recorded, my
And
Lord.
opinion is at which page?
Page, my Lord, opinion, page, my Lord, page 155. The 11 portion, my Lord, your Lordship kindly see. The 11 portion started from, my Lord, para 9, my Lord. My Lord, may I read, my Lord? one-
Just a moment.
My Lord.
Your voter list which you are showing is at page?
My Lord, of page. Page, my Lord, 86, my Lord.
86.
86, my Lord.
This my lord, translated copy. My lord, 86 Kasimuddin, son of Noimuddin, my lord. In fact, my lord,
Just a moment. This is 2005.
my lord, 2005, my lord. Seventy voter list, my lord, page.
Just a moment.
My lord, my lord.
The 87 you are showing us, which is the exhibit number?
87 exhibit 87.
You are showing us page 86. That's translated copy.
My lord,
87 is the original one.
the original one, my lord.
Now, which is this exhibit number?
Exhibit number, my lord, I'm my lord. Exhibit, the total list of. I
That's right. Mohammedan Ali Jawad in Masaf. 2005.
2005, my lord, page exhibit 4, my lord.
No,
Exhibit,
then you better check up your records.
my lord,
It doesn't tally with the trial court records.
my lord, only one line may I read in the, from the
No,
impure.
but it doesn't help us. You are showing us page 86,
My lord,
saying that there is 84, annexure, this exhibit 4. But and as per the trial court record, it is not exhibit 4.
my lord, 2005 voter list, two voter lists are, my lord, exhibited, my lord. One
Let's
is,
tell us which one.
my lord, exhibit 9, my lord, your lordship kindly see.
Exhibit 9.
2005 voter list also, my lord.
Certificate copy is a sick problem. Hmm. Mr. Sharma,
Lordship.
at least he has a vote list of his, along with his projected father. Give him bail.
Lordship, regarding bill, I have nothing to say, but Lordship, something is not matching Lordship here. In the writ petition.
Hmm?
Something is not matching Lordship in writ
No,
petition.
things are not matching, but we'll tell you why. Two things. Number one, the performance of the lawyer who was there in the tribunal is very doubtful. Whether the petitioner is a doubtful citizen or not, we don't know, but the conduct of the lawyer is doubtful. He has absolutely no idea of trial.
Right.
He has, in the affidavit, referred to annexures and not as exhibits. And a blunder which he has done is that we'll show you something. He is sending you the records. Here's a flag. This is the exhibit he wanted to show us. In the affidavit, he says it's a photocopy. And in the record, it's a certified copy. So he has no idea of how to conduct a trial. And then there's something more interesting. Correct?
Yes.
Now compare it with page 87. No, this is record. This is TCR. Compare with the writ petition.
Writ petition.
Page 87. Correct. Now look at the application for certified copy. Both are different. In the writ petition, there's a different copy, and say in the trial court record, it's a
Yes.
different copy.
Yes.
So things will not match.
Yes, Lord.
So he shall, but he has a document which connects him.
Hmm.
So you grant him bail and then we see it.
Lordship.
So that's why that mismatch, because in the affidavit, it doesn't come serially.
Yes. Lord.
2005 to, if there are two voter lists, he should have given it in a consecutively, but it's not there. So it is very clumsy. In one reading, we can't understand anything. That's one part.
Lord.
The second part is, even the tribunal has not very clearly identified the affidavits, the exhibits.
Yeah.
You look at the opinion, it's at page 155. In para 3, he has written like this, all the documents. And then at paragraph 6, this is how he refers to the exhibits, he or she, the tribunal. Now we can't understand in this manner. We are not trained to look at exhibits in this manner. Even if I ask you to now compare this with the documents on record, you'll not be able to do it
Lordship.
unless I give you at least 1 hour's time to
Lordship.
read paragraph 6 and identify the document. Hmm? So that is why today we don't have time
Lordship.
to go through each and every document in this clumsy manner. So you have giving bail. That's why we are more interested in the training,
Yes, Lord.
because if and you look at something which is more serious. In the affidavit, look at the affidavit. He says it's a photocopy. Which page is your affidavit? Evidence on affidavit. Which page is that?
My lord, it starts from, my lord, page 130, my lord.
130.
Yes, my lord.
Photocopy of
So
Annex.
everywhere it is photocopy of
Yes, yes.
photocopy of document, photocopy of document.
Hmm.
The tribunal is signing the photocopy.
Yes, Lord.
How it can be done? It should have been certified to be true. That means nobody looks into it.
Not exhibited also.
Yes. And therefore we are having an impression that we are the only two serious people in this foreigners issue. Nobody is interested.
First, up to Annexure 4, Lord.
No, whatever, but you see, is the High Court, the tribunal sign a photocopy.
Yes, Lord.
And if you don't train them, that's why in UK they say, God save the king.
Since 1979, Lordship, voter list of 1979
No, whatever
was
be, but
marked as exhibited.
since you follow the British principles, also the state should also follow that. God save the king.
Lord.
This, unless the tribunals are correctly trained, this will continue to happen. And you'll find a sarcastic comments which are unnecessary. Had Mr. A. Mannaf, learned counsel for the petitioner. All the respondents are there. The TCR which was called for from the concerned tribunal is received. Next, the learned counsel for the petitioner prays for bail pending decision in this writ petition. Most of the prayer is opposed by the learned standing counsel for the FT matters on the ground that although a lot of exhibits, a lot of documents have been exhibited, but still the petitioner has not been able to connect himself with his projected parents. Next para, be that as it may, in view of the nature of projection made in this writ petition, 10 days time to take bail of rupees 5,000 to the satisfaction of
Lord, ST Gordon Mulberry.
SP for the Mulberry. Same conditions. List and then next para, as records are received, issue rule returnable forthwith without requiring any fresh steps to be taken. Stop. List the matter for hearing in the week commencing 18/8/2025. Yes, Mr. Datta, you have been able to get it.
Yes, madam. He doesn't write Miller Abdul Manaf. He's known as Abdul Razak only.
Then it'll be your income. It will be your duty then to say what has happened to this person.
His মতে কিন্তু আমুক মানুহ আমাক হেণ্ডঅভাৰ কৰিছে দৰ্জন বিবি wife of Abdul Manaf.
Gurjan Bibi is not the wife of
Abdul Razak.
Abdul Razak.
Abdul
He's the wife of Abdul Manaf.
I will get the instruction, Lord. I will get the instruction, Lord. No, that's finished.
We take it up on Wednesday. You take a copy from Mr.
I mean, yes.
Chakravarti. He also has a representative. That's correct. Pursuant to order dated 25/6/2025, Mr. B. Chakravarti, learned CGC has produced copy of instructions received from the Frontier Headquarter, BSF, Guwahati, wherein it has been stated that on the request of Assam Police, amongst others, Doijan Bibi, Doyjan Bibi, wife of Abdul 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 Munaf, was handed over to them while handed over to them, and her name appears at serial number 27 of Appendix A. Who was sent back to Bangladesh from the AOR capital of ad hoc 2503 battalion, BN battalion, capital B, small n, BSF, Dhubri, on 27/5/2025. Next para. Mr. M. Dattar and counsel for the petitioner has submitted that he has received specific instructions that the husband of the petitioner, the petitioner, namely Abdul Razak, ABDUL, Razak, REJJAK, is the husband of Doijan Bibi, and therefore he requires the whereabouts of his wife Doijan Bibi, wife of Abdul Razak, not Doijan Bibi, wife of Abdul Munaf. Next para. The instructions as produced by the learned CGC is returned. With a request to provide the relevant instructions to the copy of relevant instructions to the learned, to Mr. G. Sharma, learned learned standing counsel for FT matters, for obtaining information about the whereabouts of Doijan Bibi, wife of Abdul Razak, against whom an ex parte opinion dated 31/8/2017 was passed by the learned member, Foreigners Tribunal 4th, Dhubri, Assam, in FT case number, again FT-4/71 GPR/2017, arising out of reference REF, reference full stop, case number IM within bracket D, bracket close T, give a space, then 806/98. This will get paragraph 4 last order. Next para. The learned standing counsel for the FT matters has sent download copy of this order to the jurisdictional superintendent, to the Home and Political B Department, Government of Assam, so to enable them to obtain instructions Next para, list on. Twenty-four. List on 24/7/2025. You are returning the message about this. Oh, acha, not 24. Then it comes to 25. There's a special bench on that day.
Thank you.
Upgraded item 21 nurse.
Yeah, please, your lordship.
Okay, he's not in a good condition. We give you a short notice.
Lordship.
We take it up next Friday, and then you get instructions.
Lordship.
He's praying for bail.
Lordship.
And in the meanwhile, if he's not well, page 18. Hepatomegaly with grade 1 fatty liver and then prostomegaly grade 1.
Kidney stone.
Ask him to give treatment.
Lordship.
Mr.
Yes, Hussein.
S. Hussain, learned counsel for the applicant, as well as the respondents are there. On the ground that the father of the petitioner namely Abdush ABDUSH Salam SALAM alias Abdul ABDUL Salam SALAM who is presently against whom ex parte opinion dated 27/9/2023 was passed by the learned member, Foreigners Tribunal, Karbi Anglong in FT case number 205/2009 within bracket reference REF reference SP case number 2454/98 bracket close is currently lodged in detention camp transit camp at Matia Gwalpara, having been taken into custody on 24/5/2025. Prayer for bail has been made by the applicant, who is the son of the detained person. Next para, issue notice returnable on 25/7/2025. Extra copies of this application be served on the CGC, State and Department Council in course of the day. Next para, in the meanwhile, if the condition of the medical condition of the father requires medical aid, comma, the in charge of the, sorry, the superintendent of the transit camp, comma, Matia, comma, Gwalpara shall do the needful to provide immediate medical treatment to the applicant's father named above. Next para, list on 25. Uh, But you will take care because because of the fact that although your father is in detention,
Lordship,
but the writ petition has to be filed by him. You, third party cannot come, even if he is a son, cannot come and challenge the opinion of his father. It will be an issue of maintainability. And the writ petition is all sides are represented. On the next date of listing, the learned counsel for the petitioner shall address the court on the maintainability of the writ petition. As the inferior opinion has been assailed, not by the concerned person, but by his son. Next paragraph. As before, comma. Oh, so this order will not come here because this is not listed today. Just strike it out, and that part will go to the IA. No, list on so and so. In the meanwhile, let's do. Okay. Good.
Item 6 for admission.
It may after some time, might be.
No, not after some time. We will go some other day. We'll have to rise at 11:30 today. There's a single bench. Both of us have a single bench. So unless there is some urgency in any matter, we may not take up hearing today. We'll pass orders so that we can fix a date.
Some early date.
This is item 6. We'll adjourn it next Friday. Positive time matter cannot be taken up today, based on Friday next. I'm just addressing the members of the bar. You are aware, you are all aware of the current situation. So this, I think next week also there will be some disruptions. You may not be able to devote full time in the foreigners matters. So you'll have to just take note of that, and we can't help it. It's a situation which is beyond our control. But we are passing today till 11:30 we are here. We are passing orders. Yes, Ms. Sultana, yes.
Item number 7, I heard
Yes.
item 7, my lord. My lord, this matter, this WPC may kindly be admitted, my lord,
Pardon me?
for custodial violence, my lord, custodial death, my lord. of the-
Yes, sir. Custodial death. Yes.
You will also directed to police one medical.
I got the medical report, madam, the final PM report. It said, madam, the disease died because of some liver problem, not of some poison and all that. I've got the report of the person.
Then we'll have to ask you to give a
Yes,
by way of an affidavit, so then she can.
I will file one affidavit in that case. I'll place the report. Flag mark A is the, my lord, incomplete report. From next page, my lord, X and Y are the, my lord, final report, my lord, that we have got from the forensic. Lung disease, for lung disease, result deaths. I file one affidavit with this.
Legal aid counsel for the petitioner is present. Pursuant to order dated. Order passed earlier. Mr. B. Gogoi, Leonard, standing counsel for the Health Department, has produced a copy of the written instructions dated 1/4/2025, along with copy of the postmortem report and report of the FSL. Okay. Same is present and returned to the Leonard's standing counsel for the Health Department, so that the same can be brought on record by filing an affidavit. Next Friday,
Yes, ma'am.
this month, 25.
Public.
My lord, petition is admitted, my lord, at this stage, my lord.
Pardon me?
This petition is admitted, my lord, at this stage. My lord, at this
We have
stage,
already issued a notice.
yes, my lord, service is complete, my lord. So I pray to admit at this stage, my
No,
lord.
once we admit it, it goes for hearing. And till now, this is not a proper stage for sending the matter for hearing.
So may kindly be admitted for hearing, my lord, and I have not got any receipt from the objection from the other side, my lord. Copy of objection.
You see, in these cases, when there is a case of death, you want the matter to be listed for hearing. It goes for, it'll come when we don't know. We are not fixing it for hearing right now. Let the affidavit be exchanged. You will get an affidavit, then you take instructions and then do it, because you are here as a legal aid counsel.
Sorry.
Once we admit it, it goes for hearing. This is not an appropriate case for sending it for hearing at this stage, when no affidavits have exchanged.
Well, on 20.
Question of objection will not be there. You say that it's a custodial death. They said that the person was taken into custody and died because of liver problem. So the death may be in the police custody, but the reasons for death, whether there is a police torture or there is anything else, those has to be decided. It can't be sent for hearing just like that. Because once we send it for hearing, it will come only after 4-5 years. No, go ahead.
Item 8,
Expiry order, my lord. Petition submitted written statement subsequently. He entered into trap, my lord, led by the
Just
Khan
post the-
corporate, and that's why my lord, subsequently expiry order, my lord. Once out may be given, my lord. He has a document, my lord. 8, 9.
We'll have to see how much is your default.
Default is admitted fact, my lord. They are not denied by the petitioner.
What is your explanation for not appearing after,
Yes, my lord.
uh,
Yes, my lord. Para 7, 8 and 9, my lord.
6/6/2023?
Para 7 and 8, my lord.
This is an explanation we can't accept.
My lord,
Because if
para
you
it
accept,
also, my lord.
if you
Right.
accept this explanation in paragraph 7,
Para it also.
then it will be contrary to the Advocates Act, where touting is prohibited.
Yes, my lord. He is a tout, my lord.
No,
Farooq
but,
Khan.
but you see, we can't give the court's imprimatur to the touting. That means we'll be accepting
to
that,
take-
okay, he went to a tout and that was a mistake and therefore you.
Yes, my lord. Para it also I am explaining. And the third person also handed over to the police twice, my lord. And he is misguiding the illiteracy person, my lord. And she is entered his trap led by him, my lord. Otherwise, she has a document, my lord. Poor lady. Para 9 also I am also explaining. And in Milot in social
No,
media,
no,
my
you
lord.
see, we find the stand very contradictory. Number one, you say that you could not pay the fees of the council
Hmm.
and therefore you stopped appearing. Then you say you went to a tout. And then you again say that the tout took 5,000 rupees.
Yes, yes, yes.
Correct. So you don't have you don't have money to pay to the lawyer, but you have money to pay to the tout. How can this be a good explanation?
Yes, Milot, the third tout is expressed, he will file case before the Supreme Court, my lord. And Milot in social media, this tout Farooq Khan is so many posts is posted, and my lord, and he laid down a trap, my lord. And maximum poor lady, poor persons, my lord, illiterate persons are entered his trap, my lord. So many cases expired order passed, my lord, in Borbetta area, my lord. And he has twice handed over to the police, my lord, by the Borbetta Bar Association. Even, my lord, the great person, my lord.
Let us think over. Today we are not in a what do you call, we are disinclined.
Yes.
So instead of dismissing, we give you
Yes.
the next date. Take it up next Friday. If we are not satisfied, that's why
I mean, like, I am.
We don't want to dismiss it today. Take it up next Friday. But in the meantime, both of us will discuss. Brothers and sisters will discuss and then think. Both sides are represented. At a positive time, the matter could not be taken up today, based on 25/7/2025.
Oh, bless. I don't know.
Item 9,
Yes.
My lord.
What is a good document to connect you to your parents?
Lord, page 52, my lord.
52. 52.
52, my lord.
It's an exhibited document.
This is an exhibit K, my lord. And also
Exhibit K.
Exhibit K, DW3, my lord. He came and authenticated the document, page 81, DW3.
Okay. Which are the relevant entries here? Your
Relevant entry is
your name
K-
is Kashbhan
Rajban BB.
BB.
Yes. This is the petition number. He bought the land, the father bought the 1993, 2007, my lord. It was mutated in the name of the petitioner.
Full statement bas nahi hoता है।
But this is a post 71 document.
My lord, so now there is 1966 document of the father, which is page number 38. This is a linkage document, so it can be post 1970.
Okay. Your name of your father is
Gyasuddin Sheikh.
Gyasuddin Sheikh.
My lord.
How do you, what is the other document to connect you to him?
My lord, there are other documents which have not been like page number 56.
No, we refer to only the exhibited documents.
My lord, page number 56.
Where is it? Where is a voter list of your father after this mutation was done in 93?
Yes.
What any voter list prior to 93 and after 93?
Yeah, 90, my lord. 1989, my lord, page number 42, 1989.
Is it the same village?
This is same village, my lord. 66 different village, but there is a statement that he shifted after 63, my lord.
42. Okay, and post 93 photo list?
He died, my lord. The mother's name is there, my lord. 1997, page number 44. Mother name is there. Father name is just written as guess. He died by then.
Mr. Sharma,
Lord, sir.
although all the documents are post 71,
Yes, Lord, sir.
but still he has a connection. That you grant bail for the time being and then
My lord.
you examine the records. Because we are not finding any connectivity. Once the 66 and 71, there is a break. Post
80
that,
66, 85, 89.
66 to 85, Lord, sir. There is a long gap. And
still that names tally, therefore we are giving
My
the
lord.
bail.
I'm grateful, madam.
Mr. A.W. Ahmed, counsel for the petitioner. All the respondents are there. Pursuant to
Page number
order dated
28.
9/6/2025, comma, the records of the tribunals, concerned tribunal is received. Stop. Next, by the learned counsel for the petitioner raised for bail, which is opposed by the learned standing counsel for the FT matters on the ground. That the linkage of the petitioner to her projected parents is not there. And moreover, it is submitted that the land document on which the petitioner is relying is also post 25/3/1971 document. Next paragraph, be that as it may, in view of the projection made in this writ petition, comma, the court is inclined to grant bail to the petitioner that 10 days time to take bail of rupees 5,000 to the satisfaction of
Dhubri, my lord.
SP, Superintendent of Police Border, Dhubri. The conditions. Next part is the records are received. The matter is admitted for hearing by issuing rule returnable forthwith without requiring any fresh steps to be taken. Next one is the matter for hearing in the this is 25 matter. In the week commencing 1/9/2025.
Issue of maintainability was also there.
Pardon me?
Issue of maintainability, lordship.
Maintainability, okay.
Yes, lordship. On earlier occasion, lordship, it was kept open, lordship.
Okay, then don't say that. Last part you strike it out. As issue of maintainability was kept open by order dated 9/6/2025, list on 25/7/2025 to hear on the issue of maintainability. Will rise for the day in the division bench. Okay, just see the approach. Item 6.
Order dated 11/6/2025.
Yes.
Yes, Your Lordship. Deeply obliged, Your Lordship.
Item 1 for withdrawal.
There's no representation from both sides. Most of the matter has been listed at the instance of the appellant for withdrawal. Stop. In the absence of the learned counsel for the petitioner, the matter cannot be closed on withdrawal. So accordingly, list the matter for hearing in usual course in terms of earlier order of the court.
Item 2
There's no representation from the petitioner. So no affidavit has been filed in terms of order dated 6/6/2025.
May I please, Your Lordship?
Yes,
Lordship, in this matter, we were supposed to file the additional affidavit, Lordship.
not supposed to, you were directed.
Yes, Lordship. Lordship, may I pray for a week time, Lordship? The affidavit is ready, but we are awaiting some of the document.
Okay. Then say that Ms. F. Ahmed, learned counsel for the petitioner, prays for further 1 week's time to file affidavit as directed earlier. So accordingly, list after a week.
Lordship.
Item 3. Yes,
Yes,
Mr.
Your Lordship.
Consilia.
Lordship, the petitioner is a tenant of the respondent and he has been in the premises since last 26 years. Lordship, the tenancy commenced with initially
it was under the uncle of the plaintiff's father. And the petitioner paid a sum of rupees 1,20,000 as advance. And after the death of Mathura Prasad Sahu, who was the uncle of the plaintiff's father, the tenancy devolved upon the plaintiff's father, that is Jai Narayan Sahu. And after the death of Jai Narayan Sahu, the elder brother of the plaintiff started to take rent. Initially, from the year 2016, January, the plaintiff started to take rent, and with effect from April 2016, he refused to take the rent. Consequently, the plaintiff, after offer, started depositing in the court. In the year 2017, the plaintiff filed a suit for eviction on the ground of defaulter and bona fide requirement. Lordship, all throughout we have been paying rent, and the rent was, after refusal, the rent was deposited in the court.
But the finding at paragraph 15 of the judgment is that you had failed to state the date on which you offered.
Correct, Lordship. Lordship, the due date has not been proved by the plaintiff. Plaintiff stated that the due date is the 3rd of the succeeding month. We all thought stated that the rent was offered in the first week of the succeeding month, and on refusal we deposited in the court. Lordship, in the appellate forum, we filed an application under Order 41 Rule 27 to bring the into the record the exact date. That petition was rejected on 5th of February. It was filed in 2020, immediately after the appeal was filed. That petition was rejected on 5th of February, and immediately on the same day, the argument on appeal was heard, and the next week, 13/2, the judgment was passed, Lordship. So our application for adducing additional evidence was rejected, Lordship. So at this stage, may I pray the notice may be issued?
No, but if you see, as per the law laid down with the Supreme Court in Ibrahimuddin, the prayer for Order 41 Rule 27 shall only be considered at the time of hearing.
Correct.
So, but when at the trial court, do you have the evidence, copy of evidence of the plaintiff? Is it available? PW1,
I have not enclosed, Lordship.
do you have a copy of that?
Yes.
How did you cross-examine the, is that part brought on record by cross-examination about the due date?
Lordship, about the due date, there is no cross-examination. But one important point, Lordship, has regard the security deposit that I have paid 1,20,000 to the uncle of the plaintiff. He stated that he has not informed him. He has not denied that part of the evidence.
We did not get it. Please repeat again.
My specific contention was that initially, when the tenancy commenced, I paid 1,20,000 to Mathura Prasad Sahu. Thereafter, plaintiff's father became the landlord. And after the death of plaintiff's father, Shiv Kumar Sahu, the elder brother of the plaintiff, started to take rent. At that stage, I paid another 35,000 as security to the elder brother of the plaintiff. This part of the evidence has not been denied by the plaintiff in his cross-examination. He has admitted. Plaintiff has categorically stated in his plaint that he has taken 35,000 as loan from me, whereas he himself stated that my financial condition was very bad. When my financial condition was very bad, how can I lend money? That advance was never adjusted in my dues rent, if at all there was dues. The issue as regard advances were also not adjudicated. And
has the trial court dealt with that aspect? I've missed it out then. Trial court judgment?
In the trial court judgment, issue as regard advances were never framed, Lordship.
Then?
And has para number 19 of the appellate court judgment say, since there is no evidence to show that the rent was offered, Lordship, while rejecting my prayer for adducing additional evidence, the learned trial appellate court held that I find the additional evidence sought to be adduced is not required to decide the appeal. That is not required. Whereas in para 19, the court on the next week said, since there is no evidence to show that the rent was offered, and that is what I want to adduce by way of additional evidence.
Which paragraph, please show?
Peda 19 of page 88, Lordship.
88.
Lordship, this is the only source of my livelihood. I am last 26 years I am in that shop running.
Where is your prayer under order 41 rule 27?
Lordship, that is at page 65, Lordship.
65.
Petition start from page 61, Lordship.
But if you are showing us this order 41 rule 27, then paragraph 6 goes heavily against you. Because here you have admitted that you have stopped offering rent. Line number 6 or 7.
That I have seen, Lordship.
Then we'll have to dismiss your petition. Because once you admit that the offer was stopped, then additional evidence is not required under order 41 rule 27. Because after Ibrahim, there are only two parameters. Number one, the evidence must have been prayed for before the trial court and refused. Then only order 41 to 27 can be made applicable. Otherwise, it would be amount to filling up the lacuna in the evidence. And now in this paragraph 6, you are also making allegations against the lawyer that he had missed the date of offer.
Lordship,
We can't allow order.
all throughout, we have stated that rent was offered in the first week of May. And a specific date was not mentioned.
No, but you see, I forgot the judgment. I'm taking off this bench after a long time. I forgot. I think Abdul Mateen Chaudhary.
The dependency of the suit also.
No, not even pendency. All throughout, he must make an offer. So there also you fail.
Lordship, I have gone through this apartment. I have to admit that, but otherwise my instructions are that all throughout we have offered, and the evidence says so that we have offered in the first week of.
Then Mr. Khaneria, you are not inclined. We'll have to dismiss your revision.
I may be allowed to take some more instruction on this, because this line I have read with all due respect, Lordship. I have also seen this.
Okay. On the prayer made by Mr. G. Khandelia and counsel for the petitioner. Matter stands adjourned today. List after 2 weeks.
Lordship, can it be after 3 weeks? Because
3 weeks,
between 25 to 5, I will not be.
Okay, 3 weeks.
Item 4.
In this case, your lordship, pursuant to order dated 15/7/2025, your lordship, Honorable Court was directed to file an additional affidavit annexing the plaint, your lordship. Yesterday we have filed, your lordship, but it has been not tagged with the record.
Okay. List this matter on 23. 725 along with additional affidavit. Additional affidavit
Yes, Lordship.
Stated to have been filed by the petitioner today.
Yesterday.
Filed on. It'll be 17/7/2025. Or rather say it like this, that Lieutenant Counsel for the petitioner states that an affidavit has been filed on 17/7/2025, which
Which
is not on
and-
record.
Acknowledge.
List on 23/7/25 along with the said affidavit.
I'm sorry, Lordship.
Item 5.
May it please your lordship. Lordship, the matter is listed for admission. It will take some time, your lordship. Lordship, today the court is rising early. And the opposite party is also not here, I suppose. He was also.
They've entered appearance.
They've entered appearance. Maybe fixed. We have some urgency, so next week if possible, your lord.
Okay, Mr. B.J. Mukherjee, Lieutenant Counsel for the petitioner, fairly submits that the respondent numbers, the counsel for respondent numbers 1 and 2 are absent. Stop for injustice, the matter stands adjourned today. List on next Friday, 25/7/2025. Much obliged. This item 7.
May it please, my lord. I beg to appear for the appellant, my lord, the petitioner. My lords, in this case, on the 14th of May, by a judgment of this court, my lords, the delay was condoned. And my lords, we were asked to pay the court fee. We've complied with that. And now, my lords, this appeal comes up for admission. Our case, my lord, was that before the reference court, my lords, even though an impleadment application to implead us via the, my lords, requisitioning authority, the acquiring authority is the state. There was an application filed by the state to implead us, my lord. But my lords, this application was not decided and eventually we were not aware of. And my lords, there's a correction also that takes place subsequently. And then, my lords, we have now filed this appeal challenging both the orders dated, my lords, 4th of March 24 and 6th of
Just
April 24.
you say that that application was not, no orders were passed on that application.
No order was passed, my lords. We have filed the orders of the reference court that starts, my lords, from page 147 of the appeal paper book.
What?
My lords, we'll see the orders one by one, and I will show, my lords. 147, my lord. Orders start. 147, my lord.
You're for?
Lordship, I am for the respondent number 4 to 10, Lordship. Lordship, no copy of the memo of appeal has been served to us, Lordship. Lordship, kindly a date has been given so that we can.
Just a moment.
My lord, we have already served, my lords, on the last occasion. There were detailed arguments made on the application for combination. The opposite party has already argued the matter, my lords. That argument cannot be made, unfortunately, my lords. That's my humble submission. And my lords, they have now, what they've done is, despite the pendency of the appeal, the executing court execution.
But the council says the
The last date we have argued on the IA we have filed, Lordship. But
council says he had not given him copy of the copy of the memo appeal.
But Lordship, no copy of the memo of appeal
Well,
is
the
given.
memo of appeal, well as the application, well as my submission is that the application will also include, my lords, it will be included in the appeal paper book, my lords. The entire
No,
set
then
of
you are wrongly,
papers were-
then you are wrongly instructed.
I'm
If
sorry,
you
my
say,
lords. I'm so sorry.
if you say that the application, along with the application, this is given, but then there's no acknowledgement on record.
I'm so sorry, then, my lords. I am not aware of the records of the case. But, my lords, I have only one submission. Today, my lords, I am only on the point that the execution should not be proceeded. We filed an application before the executing court. My learned colleague,
You give her a copy, we'll take it up next Wednesday.
next Wednesday, my lords. I'm obliged.
But give
We
a
will
copy
serve
to
a
the other
copy.
side.
My lords,
The execution is coming up on Monday, my lord.
On the 20, my lord, I am told that the execution petition is coming up on the 20th.
On 20.
21st.
Lord's could keep on my 21st, my lord. Can this be kept on 21st, my lord?
But Lordship must of station
We'll serve a
Lordship.
copy.
Lordship
No,
kindly-
no, for that we don't have to hear the issue of stays between the petition and the court. You may object, you may not object.
But Lordship,
But we can't allow, we,
Lordship, they have not filed any stay petition yet, Lordship.
pardon me,
Yes, Lordship.
please repeat
Lordship,
again.
they have not filed any state petition for Lordship.
Stay application is not,
Lordship.
The application is not separate, but then in the prayer, in the appeal, my lord, we've already put in.
First, let them file the stay petition, then we'll file our
please
objection.
just have some patience, Learned Counsel is responding.
My lords, if my lords will kindly see. The
Page
prayer at
39.
page 13. Page 13.
Your name? Your name?
My lords, Chinmoy Sharma, my lord.
Oh, acha, I'm sorry, I missed you.
I'm sorry, and my lord.
But Mr. Sharma,
Yes, my lord.
you see, can you come to page 41 of your brief?
Yes, my lord. I'm on page 41, my lord. The certificate, my lord.
It's only a certificate. So
Yes.
is a prayer for stay covered by a certificate or you require an affidavit?
No, my lords. Will kindly see page 39, my lords. 39, the part of the prayer. Lord. Kindly come to the prayer portion, page 39. I'm so sorry. Bottom of the page, my lord.
No, but this prayer is not supported by an affidavit.
That is not, my lords. I also did not see an affidavit, but I thought that is the format in the High Court, my lords.
Separate application, she
I-
is right. The
My
council
lords,
of,
we will file that application. My lords, nevertheless, my lords, I will just point out one thing. Kindly see para 4 of the judgment of 14th of May. They have filed a comprehensive objection, not just to the application for confirmation, but to the maintainability of the appeal also. So to say now that they have not been served, my lord, may not be correct. I mean, I'm not disputing what my learned colleague from the opposite side is pointing out, but I am only going from the records. Kindly see page
no,
number
I'm
18,
sorry.
para 4.
My difficulty is that I come from the old school.
Right, my lord. My lord, I leave it to my lord. The only anxiety from our end, my lord, was
Tomorrow is a working day. You can
Yes.
file it. We will take it up on Monday.
I am so deeply attached, my lords. I'm so deeply attached.
Lordship, kindly give a date on August, Lordship. If senior is
Then,
not there,
no,
Lordship
no.
will be handicap, Lordship.
Then you give an undertaking that you will not execute the degree. You can't have both things together.
Lordship.
Are you instructed to give an undertaking to the court not to execute the degree?
Lordship, I don't have such
Then-
instruction.
Then now you transpose yourself from this side to that side. Correct?
Yes, Lordship.
Can you come to that side? Will you like it?
No, Lordship.
No. Okay. So that answers. So once there's an execution and it's land acquisition would be a huge amount. What is the amount? What is the value?
Lordship,
My lord, 9 crore, around almost 10 crores, my lord.
Then
That
would you want that amount of money to be paid and then we hear a paper degree?
Lordship, can I have a second to receive an instruction from my senior?
You take it, whatever is there, before we rise, you do whatever you want, but we are fixing it on 21st.
Yes, Lordship, okay.
Uh,
My lords, I'm obliged. My colleague will be there, my lords, to assist my lords.
Heard Mr. C.P. Sharma, Learned Senior Counsel, assisted by Mr.
T. Marwar. And Khera and T. Marwar.
N. Khera, Learned Counsel for the appellant, as well as Miss
J. Bezbora, Lordship.
J. Biswarwa, Learned Counsel appearing for the private respondent numbers
4 to 30.
4 to 30, 30.
Yes, 30.
4 to 30. Government is, nobody is there for the government?
But somebody was appearing for the state. State is only a acquiring authority.
Next para, the The learned counsel for the private respondents pray that a copy of the memo appeal be provided to her. So that the memo appeal be provided to the learned counsel for the petitioner in course of the day. Next para, the learned counsel for the private respondents also pointed out that there's no interlocutory application for a stay. Don't say it like that. You say that the learned senior counsel for the appellant has submitted that there is some urgency in the matter as the execution proceedings is slated to be taken up on 21/7/2025, and therefore he intends to press the stay. Stop.
Lordship,
In this said aspect, the learned counsel for the private respondent submitted that there is no stay application along with this memo of appeal. Next para, the learned senior counsel for the petitioner craves leave of the court to file a stay application. Next para, list on 20, in view of the urgency expressed, list on 21/7/2025. Yes.
no Lordship, sorry for interruption, Lordship. I have another matter in court.
Please leave.
Lordship, may I leave?
Please leave.
I'm obliged. I'm so deeply obliged, my lords, for the indulgence.
Okay, you're there.
I'm sorry, my lord, I missed.
You want to withdraw it?
I withdraw, my lord, with the
Okay. Upon instructions, the learned counsel for the
appeal.
appellant, Mr. V.K. Barwal, learned counsel for the applicant, seems to withdraw this appeal. So prayer is allowed. The matter stands dismissed on withdrawal. Next para, did the LCR let the records be returned back to the learned concerned court along with a copy of this order to be made a part of record.
Yeah, Mr.
Yes, item 17.
Yeah, please allow. Lordship, may please come with the plain pilot, filed by any manner, at page 19, annexure 1.
You're the plaintiff or the defendant?
And the plaintiff and the appellant.
You're the plaintiff.
Yes. Well, the plaintiff number 1 happens to be the mother and 2 her daughter.
Where is the plaint?
Plaint at page 19, my lord.
19.
Yes, my lord. Annexure 1. This is a, my lord, stood for declaration and injunction.
Against
Lordship-
bank?
Yes, my lord. That will show.
Against bank, you took a loan.
Yes, my lord. No, I didn't took a loan. My son, who is defendant number 1, my lord.
Then the suit will not be maintainable. Your
But
plaint was rejected.
Yes, my lord. There is a plaint for rejection of plaint was filed, my lord. On the ground there, my lord, if it is secured asset in the surface, my lord, so it has to be rejected. But the fact of the matter, lordship will find lordship may come to impugn judgment, my lord. Impugn order, my lord.
It's not even required. You see, after the Supreme Court judgments in 2023, the tribunal, 2022 or 23, I forgot. The tribunals can take up any matter, including fraud.
Yes, my lord, fraud has been committed. With that, my
So
consent, my
even
lord,
then, the tribunal can take it up.
my lord may kindly come to,
Has notice been issued under 13(2)?
no, my lord.
Surface Act? No.
Lordship may come to impugn judgment, page 78, my lord. The very issue, my lord,
Just a moment.
is the impugn judgment, my lord.
Just a moment.
Page 80, my lord. The impugn.
If, just tell us if section 13(2) notice has not been issued,
Lordship,
why you are making a prayer number C at page 23, injunction restraining the SBI from disturbing peaceful position. Why you have made that prayer?
Lordship, may I please?
Just a moment.
Yes,
You have
my lord.
urgency because in cities like Calcutta, you have a bus which comes on time or train comes on time. If you don't catch a 12:15 train, you miss it. Is it like that? You want to rush to railway station? Then please have patience.
My lord, my prayer in the plaint is that for a declaration, my lord, for declaration plaintiff and the defendant being the legal heirs of the said deceased Suren Suikia are entitled to get 1/3 of the share of the residential building, my lord. This is my prayer, my lord, and lordship will find at page 24.
Oh, don't see all those things. We come to page 35. In page 35, the bank has initiated recovery proceedings. There is an RC of Debt Recovery Tribunal.
Page 35, my lord, paragraph 23, my lord.
Paragraph 22.
22. Thereafter plaintiff bank
And then in para 21 also, there
But
is a
that
debt
is
recovery.
against my son, my lord. His son does not stay with me, my lord. He has left the house.
Very good, good family.
But the thing is that the 2009, my husband purchased a plot of land and constructed the foundation of 5-story.
These things you will have to agitate before the Debt Recovery Tribunal. Civil suit is
But
bad.
the secured asset, my lord, is only the land, my lord, not the building, my lord. That is the. crux of
That was the first year in the LLB course. Anything attached to earth follows the land.
That when the entire building, when
You are reminding me of 1988 when I studied law.
things embedded under earth, but can it be a full-fledged building, my lord? That was before.
I don't know. Definition of land is anything attached to earth.
My lord,
But you have a good news. Few days back in the internet, I saw that there is a building coming up somewhere, which is floating building.
My lord, for a
You check
moment.
the internet, floating building, you will come to know about 20 or 30-story building coming up.
My lord, the thing is that, my lord, my husband, he took a blank paper and somehow obtained the sale deed, my lord, and that he has given as a security in the bank to obtain loan, my lord. And now nowhere in the bank documents this building will be found, my lord. And bank also knew, my lord. Lordship may kindly come to the valuation.
But these things are normal. Today, if you catch hold of my wife, you will find that she is having one of my check, blank
And
signed
also
check.
the notice
Because if
issued-
I am in court, she may need some money and she will go to bank and take it out.
Lordship may kindly for a moment annexure 3, my lord.
No, but what is wrong in that? I gave a check.
Yes, my lord.
She has a check of mine, blank signed check.
Yes.
What is wrong with that?
My lord, whether that.
I can't, I don't have a use of ATM card. My wife has my ATM card also. So what is wrong in that? When I give a blank signed check, document, I give it with authority to the other party to fill it up.
But in this case, I have not.
Mr.
given my-
Bakshi, I've been knowing you for so many years. You never gave me a blank signed check or
No.
blank document.
No, no, no.
I know you for so many years. You don't give it to me. So father gave it to son and son has used it.
The thing is that, my lord, I myself and my daughter will be homeless, my lord. When I come to road, my lord. Because-
I'll have to tell you another story then.
My lord, this is the fact of the matter, because I cannot do anything against my
Let me
son
tell
and-
you another story. About 6 months back, I was ill. I went to a doctor. He checked me up and then said that, sir, you don't have a heart.
Artificial heart. my lord.
So,
Will-
so even the doctor can't find my heart.
and nowadays
Heartless fellow.
Medical science has improved.
After
my lord.
once you go out, you'll have to say heartless fellow.
My lord, may kindly say valuation of the building and property is around 2 crores and loan only 30 lakhs, my lord.
You know the law, Mr. Bakshi.
Yes, my lord. But scope is limited, my lord. Whether building along with the land is there as a security asset or only the land.
These things before DRT. You wanted to say something?
Lordship, as Lordship asked for, if the notice under section 13(2) was
Yes.
issued, yes, it was issued.
Where is that?
If,
Against the son.
we have the paper book, we filed.
Pass it on.
My lord, it is only when these notices from the banks were coming, my lord, we came to know, mother and
No, we don't know. We ask specific questions, specific answers. Just one query. You already have a order from the tribunal
Yes.
for recovery of debts.
Lordship, we
Uh,
filed OA was allowed. Then they filed essay was dismissed. Then a writ petition was also filed by them, that was also dismissed.
Where is that? Give us those details.
Lordship, actually my senior is out of stations, so the matter may be listed in the first week of August. We'll
No,
file
we are not adjourning. Just you have, if you have the writ petition number, give it to us.
writ petition number is there. 7790/2022.
Just a moment. Please give it again.
That writ petition was filed by the respondent number 1, Lordship.
Who is R1?
The son.
Bulbul Saikia.
Mortgage.
He is the son.
Yes, borrower.
WPC
7790
7790
of 2022.
of
2022.
2022. Give the status. And this was dismissed on
It was dismissed 6/12/2022.
6/12/22.
2022.
Okay. Then you say that essay was filed.
Essay was also.
What is the number?
Essay number 81
81
of 2019.
2019. Dismissed on
Disposed of on 38/2019.
38 2019. Then
OA.
appeal before the DRAT.
DRT OA was also filed.
OA. Yes.
262 of 2018.
This 81 of 19 essay was filed by whom?
By the borrower.
Name.
Bulbul
give-
Saikia.
huh?
Bulbul Saikia.
Bulbul Saikia. That's mean R1.
Yes, respondent number.
Okay. OA 262 of
2018.
this is by SBI.
SBI.
Who was the
SBI
both of them are parties. This
against Bulbul Saikia. Respondent.
only Bulbul Saikia.
Yes. It was allowed on
Yes.
11/10/2018
18.
and recovery proceeding is pending before the recovery officer.
What is recovery proceeding called? RC cases.
See.
Oh, you showed us this. We close the book. Please find out that document. 13.2. Notice.
My lord, in the code below, my lord, may I, my lord? The code below, Lordship may kindly see page 91. We have relied on its decision of a high court, my lord. Page 91, my lord, last paragraph. Page 91. Learned counsel for the plaintiff has referred to the judgment of Honorable Kerala High Court in case so and so, reported in RSA number so and so, where
Before reaching Kerala, you'll have to stop at Delhi.
my lord, because wherein it says that yes, court has some jurisdiction, my lord. May I read, my lord?
But Guwahati Kerala is there a direct flight or you go via Delhi? Once you go via Delhi, then last year there is a Supreme Court judgment says that High Court should not interfere in service matters.
But that there is a distinction, my lord. That has been discussed, my lord. When the civil court has jurisdiction to try cases involving right title interest on the property involving and when the property does not come under the definition of secure assets. Learned counsel has pointed out point number 11 where it is mentioned However, to a very limited extent, jurisdiction of the civil court can also be invoked, where, for example, the action of the secured creditor is alleged to be fraudulent, or their claim may be also so absurd and untenable, which may not require any proof whatsoever, or to say precisely to the extent the scope is
But there is
permissible.
a specific judgment by Supreme Court.
Yes.
Frauds can be taken up, issue of fraud can be taken up by DRT. Very specific judgment.
But thing is that, my lord, initiated against my son, my lord. But we are the aggrieved person, indirectly, my lord. Son has left, my lord, absconded. That is the worry, my lord. As Land Council pointed out, para 13, the jurisdiction of the civil court is not barred if the plea is that the plain scheduled property is not the secured assets. Yes, it is not the secured, in respect of which a secured interest is credited. Here in this case, only land, my lord. Civil court shall decline jurisdiction if it is found that means of adjudication that the dispute property is in fact secured. Let the trial continue, my lord, then it will come up whether it is secured asset or not. Any person aggrieved can also move the debt precluder under section clarification about the measures taken under section 20 decision. In case the bank limited case is approved and does not mitigate against Jagdish so case when the property is admittedly a secured asset. From the judgment, it appears that the section 13(4) empowers the secured creditor to take recourse to several measures in case of borrowers fail to discharge its liability within the period specified. From the judgment itself, it appears civil court has very limited jurisdiction, but has jurisdiction, my lord, only when the property does not come under the purview of the secured assets and there is fraud committed by the secured creditor or any person. Well, I have both the ingredients, my lord. Let us lay evidence, my lord, before the court below, my lord, and everything will be crystal clear, my lord. And in course of time, you can also, my lord, this councils below, my lord, made a mistake in not challenging the sale deed, my lord, in the title suit. That is admittedly a defect, my lord. That ought to have been challenged, my lord.
You see, the difficulty is that, come to page 23.
Yes, madam.
This page 23 is the great difficulty.
Yes.
You say that your son manufactured a document from the blank signed document. Correct. Have you challenged that document? No.
That is admittedly the defect is there, my lord. We will amend the petition, my lord.
Ah, very good.
Because this we have not
Very
we have
good.
not drafted this petition.
No, it's okay.
Yes, my lord.
We have not asked who drafted it.
Yes, because
Correct.
we have readily told my client, my lord, what you have done.
No, that's
because of-
okay.
Well,
You-
but
you-
fact of the matter is that fraud is there, my lord, and we will be homeless, my lord.
he can't
We are
help
not
it.
aware of the proceedings, my lord.
But Mr. D.K. Bagchi, Learned Counsel for the petitioner, and also Miss
As they,
N.
as they.
S. D. Learned Counsel for the respondent number 2.
Respondent number
2 to
three.
4.
2 to 4.
3,
2 to 4.
2 to 4. Huh? Will be appellants. Next paragraph. By filing this regular first appeal, the appellants have laid challenge to the order dated 3/6/2025 asked by the learned civil judge within bracket senior division bracket close Dibrugarh in MISJ case number 227 of 2023. So by the said order, the learned trial court allowed an interlocutory application filed by the respondent numbers 2 to 4 under order 7, rule 11, read with section 151 of the CPC for rejection of plaint. Amongst others, on the ground that the suit is barred by section 9 of the CPC and section 34 of the SURFACI Act. Next paragraph. From the submissions made by the learned counsel for the petitioner, appellants, the projected case of the appellants is that they are the legal heirs of late Suren Saikia, and they claim to be entitled to 1/3 share from the residential building described in Schedule B of the plaint. Accordingly, not accordingly, it is the further case of the appellants that though the land in question belonged to late Suren Saikia, the respondent number 1, who is the son of late Suren Saikia, had mortgaged the land against loan availed from the respondent number 2, i.e. State Bank of India, Thana Sariali branch, Dibrugarh. The learned counsel for the appellants project that though the land was purportedly mortgaged to the State Bank of India, the residential building was not mortgaged, and therefore the State Bank of India had no right to take over the residential building of the appellants who have 1/3 share each on the said residential building. Next part is for the projected case of the appellants that after the bank officials started coming to their house, they came to learn that late Suren Saikia had sold the land to the respondent number 1 by sale deed bearing deed number 122 dated 21/1/2014, registered with the sub-registry at Dibrugarh, Full stop. It is claimed that the appellants were never disclosed about the transfer of ownership of the land. And thus it is projected that as only the land was sold and not the residential building, comma, the said residential building, comma, described in Schedule B of the plaint was not the subject matter of any mortgage. Full stop. Accordingly, comma, claiming that the appellants have a right to retain the residential building to the extent of their respective shares. Comma, projecting that the cause of action arose on 26/10/2020 after creation of the mortgage over Schedule A land, and 27/3/2023, comma, the date of confirmation of the loan, comma, the appellants had filed a suit valued at rupees 1,18,12,070, comma, they were claiming the following reliefs, page 23. Mr. Bakshi, just tell us one thing. The plaint was rejected.
Yes.
Was no consequential order passed in the plaint to
No.
dismiss the plaint?
Yes, no.
It's not passed. Next, the respondent numbers 2 to 4 contested the suit by filing a written statement. They also filed an application for rejection of plaint. Most of the land council for the said respondents has further submitted that initially a recovery application was filed before the Debts Recovery Tribunal, comma, Guwahati, against the respondent number 1, which was registered and numbered as OA 262 of 2018, in which recovery certificate was issued in favor of the State Bank of India on 11/10/2018. In the meanwhile, a sufficiency notice under section, a notice under section 13(2) of the Sufficiency Act dated, a notice dated 3/4/2018 under section 13(2) of the Sufficiency Act was issued in against the respondent number 1, comma, intimating that the total outstanding dues is to the extent of rupees 1, 25, 22, 604.62 intimating to the respondent number one herein that regarding the security documents at Schedule B thereto, the list of hypothecated movable properties described in Schedule C thereto, along with creation of equitable mortgage on the immovable properties being part Roman 2 to the Schedule C thereto. Full stop. It is further submitted that against the SURFACE notice issued to the respondent number one, the said respondent filed a SURFACE application before the Debts Recovery Tribunal, Guwahati, which was registered as SA 81 of 2019, which was dismissed by order dated 30/8/2019, right?
Yes.
30/8/2019. Full stop. It is submitted that no appeal was preferred before the Debts Recovery Appellate Tribunal against the order dated 30/8/2019. However, the respondent number one thereafter filed a writ petition. Where is that? 11? Which was registered as WPC 7790 of 2022. To assail the order dated 21/10/2022, passed by the District Magistrate, Dibrugarh, as well as to assail the vacation notice dated 29/10/2022, passed by the authorized officer, SARB, SBI, Jorhat branch, and further seeking time till March 2023 to make payment of the dues under one-time settlement dated 31/1/2022. Stop. Paragraph. First of, they said that petition was closed by allowing the respondent number one to file a fresh OTS to the bank within 10 days in respect of 3 accounts. And thereafter, the bank would intimate to the respondent number one as to whether they are agreeable to such proposal of one-time settlement. And it was provided that if the bank accepts the OTS proposal, the respondent number one would do the needful according to the OTS. However, till such communication by the bank, it was directed that no coercive action shall be taken against the respondent number one. Thereafter, the appellants herein have filed the suit being TS number 65 of 2023. Next paragraph. The learned counsel for the petition has submitted that the respondent number 1, who is the son of respondent number, appellant number 1, this Manju Saikia is the mother.
Yes.
The son of has left the household. Next paragraph. The issues sought to be raised by the learned counsel for the petitioner, that whether the residential building would be covered by the definition of land is an issue which is required to be adjudicated and decided by the learned trial civil court. And as to whether the issues relating to lack of mortgage of the residential building, we also left to be decided to the civil court. Are issues which are best left to be decided by the competent court of the forum having jurisdiction. As any comment by this court would highly prejudice the may have a tendency to prejudice the appellants. Full stop. As the documents available on record reveal that the owner of the land, who is the husband of the appellant number 1 and the father of appellant number 2, is found to have sold the land by its sale deed dated 21/1/2014. And having noted that the State Bank of India had accepted the mortgage of the said land as its security asset to grant loan to the respondent number 1, the court is of the considered opinion that whatsoever action that is proposed to be taken by the State Bank of India, i.e. respondent numbers 2 to 4, are squarely covered within the scope of the SURFACE Act, 2002, Full stop. Therefore, comma, the court is of the considered opinion that the learned trial court has correctly taken note of the provisions of section 34 of the SURFACE Act, which bars civil court of any jurisdiction to entertain a suit where the subject matter relates to SURFACE Act or actions taken thereunder. Next paragraph. Even if the full stop. From the prayers of the suit, comma, extracted herein before. Comma, there is no prayer in the set plaint regarding fraud, comma, if any committed by respondent number 1 in mortgaging the secured assets or any fraud committed by the State Bank of India in accepting the mortgage, comma, the issues raised in the plaint can effectively be adjudicated before the Debts Recovery Tribunal having jurisdiction over any action taken by the bank under the SURFACE Act. Next paragraph. Having arrived at the said conclusion, comma, court does not find any merit in the challenge to the
Regarding my lord, concealment, it has been alleged in the plaint at paragraph 7, my lord.
what?
In paragraph 7 of my plaint, I have stated that my son, without my knowledge, has,
Oh, without your knowledge, many things happen.
and surprisingly, you know, all these things are there, my lord. In
Many
paragraph
things
7.
happen.
Directly fraud word is not used, but
Many things happen without your knowledge. Can any father in the world come and say that, yes, my son will not do something without my knowledge?
also, my lord, can a father sell his land to his son, my lord? Presumption.
Why not?
His own property.
Is it,
in spite of his
are you hearing it for the first time in your professional life?
wife and daughters are there equally.
Have you heard this sale for the first time in your professional life? If you have heard for the first time, we are very sorry.
Rarest of the rare, my lord.
It's not a question of rarest and rare. Have you heard it in your professional life or not?
Yes, yes. Once,
You have heard.
rarely.
Because if you have not heard, then we are sorry.
But thing is that we will become. But thing is
You
that
don't question, you see, whatever you say, this statements made has prompted the court to ask a question which is uncomfortable. Even I don't like it. You are touching upon your own professional competence. Is there any bar anywhere in the world that this father cannot sell property to son?
No.
Then
I leave up to your lordship, my lord.
so don't make us tell us things which we don't like. You know my character. I start with a smile. I want to end up and go home with a smile. Don't make me change my character. Because I know how to retaliate. I don't do it because it's not my normal normal behavior. But if you ask me uncomfortable questions, I know hundreds of answers. You'll feel more embarrassed than me. And I'm really sorry I'm asked that question because it's not for me to judge a professional conduct. When you say that, when you put a question to the court, can a father sell to the son? Then you're questioning your own professional ability. Section 54, you don't know of the Transfer of Property Act. What is sale? Don't make us put that conflicting questions, but I'm sorry. Met the challenge, so accordingly, the impugn order dated 3/6/2025 passed by the learned civil judge within bracket senior division bracket close Dibrugarh in Mijje case number 227 of 2023. Stands affirmed and this appeal stands dismissed at the admission stage without issuance of notice on the respondents. I toast. This is a caveat discharge. Yes.
Obliged.
Deeply obliged.
You take back your book. Item 8.
Please, Your Lordship.
Appellant number 1 expired.
Yes. Appellant 1 expired and he has been substituted now.
Substitution is allowed.
Yes, allowed. And
What is the order?
amended cost title also, my lord, we have annexed, my lord. That order.
What is the substantial question of law involved here?
My lord, the question of law, initially, it was there. These are the questions, my lord.
We have it at page 12.
No, my lord, that is different. Those questions, my lord, will find, these are not
No,
questions.
but then
of-
you'll have to bring it on record.
That is, those are, my lord, because initially.
So then bring it on record. Because I'll follow order section 103.
It says that it should be formed part of
It
the
should form a part of-
the memo of appeal.
Bring it on record. Mr. A. Das, learned counsel for the appellant, seeks liberty of the court to substitute the substantial question of law available at page 12 and 13
Yes.
of this memo of appeal. So prayer is allowed. With the necessary substitution be done, substitution of substantial question of law be done in the presence of AOJ civil appeal section, second appeal section. Thereafter, the matter be listed immediately thereafter. Immediately thereafter, we have said.
Because these, my lord, your lordship, these are not questions of law, these are questions of fact, my lord.
No, we don't know. No, I did not apply my mind. Today, today this little
Later on,
paucity of time, I
yes,
couldn't
These are
do my
not
homework well.
questions Because later on, my lord, you entered.
It's
evidence
okay.
in This case, I'm obliged.
Just saying it in a lighter note, today I didn't do my homework well. Yes, next item. Item 9.
I please, Your Lordship.
Yes.
In the last day, it was ordered to give notice to the respondent number 2 and 3, Lordship.
Yes.
We have already given a registered as well as normal post, Lordship. Respondent number 2 and 3.
Has service report come? Insufficient address. No, I'm sorry, we have to take fresh steps, but this is 2023 steps taken.
Yes, Lordship. 2023.
Okay. Mr. P.D. Bhuyan, Learned Counsel for the appellant. As as per office note dated 15/6/2025, notice was duly served on respondent number 2. However, notice on respondent number 3 could not be served. The postal steps taken on respondent number 3 has been returned back with postal remark insufficient address. Who is respondent number 2?
Vasanth Burman.
No, not the name. Who is he?
He's the owner, Lordship.
He's the owner.
Owner. So number 3 is the driver.
Okay. Yes, the matter is listed after 2 years from the date of service on respondent number 2, the appellant shall take first steps for service of notice on the respondent numbers 2 and 3 by registered post with AD. Steps to be taken within 2 days. Next para, the learned counsel for the petitioner is at liberty to collect the postal receipt number from the registrant to submit postal track report prior to the next date of listing. Just notice is made returnable. Give a fixed date after 5 weeks. You take within 2 days because we are giving a fixed date for return of service. But the postal authorities are right. Respondent number 3 address is house number 128 Samanya Complex, Dispur.
Yes, Lordship.
Nobody will be able to find out this address. Your steps will be wasted.
Clear. Lordship, will be possible. It will not been possible for us for find the address, but we'll try to find it.
Yes. Nowadays, we have a very interesting things in our mobile. You can search it out. If you have a name of the building, you can search it out. It's very easy.
In the map only. Yes.
I don't know. I'm weak in many things. But we have something available. Do it, I think, bring it on record. We list it after a week. You get the correct postal address on record. Don't say that. You have said that insufficient. So accordingly, we grant 1 week's time to the land counsel of the petitioner to provide the correct postal address, to bring on record the correct postal address of respondent number 3. So, orders will be passed on the next date for issuance of notice on the respondents. Number 2. In 10, what is there? Same thing.
Item number
10. No.
These are 2 appeals. No. In this appeal, there are 2 appeals. We have passed order in 1. What is the order required to be passed in 2nd?
Same, Lordship.
Same.
Order.
Okay, separate. Okay. Yes.
Much of.
Item 11.
Item number 19, Lordship, may be taken on Wednesday.
19
of supply.
Why it has come for orders?
Because Lordship, the parties had appeared Lordship and there is a injunction petition to be considered.
Okay.
Lordship,
Ajit, just take a note.
sir, আপনি কোনটো কাৰণে question?
Just take a note, item.
I am appellant.
মাতিছিলে যে এখানে।
You're there? No.
Lordship, I don't.
No, no, my learner friend is appearing.
Oh.
He is appearing for the.
All these matters will be adjourned. Item 11, what is the order, Ms. Keshi?
Pleadings are complete, your lordship, in this case, so it may come up for admission hearing.
Okay.
But
Item
since on
11,
the last date, they
this,
continue the interim. I'm going to respond in your lordship.
okay, item 11, Ms. N. Keshi.
I'm petitioner.
You're there?
A petition.
Okay, both sides are represented. The learned counsel for the respondent submits, Ms. N. Keshi, learned counsel for the respondent submits that the case is ready for, the pleadings have exchanged. Expert accordingly lists the matter for admission on, give a date in these matters.
That's the interim may be continued.
Just a moment. I won't be
Interim
taking-
may be continued.
Huh?
Interim may be continued.
Interim says that not continued.
Last date, they have not continued the interim.
Then if you file an IA, if the interim was not continued on the last date, you have to file an IA for extension. Ms. Keshi says that on the last date,
That is in
interim order was not extended. Take it up.
During motion. period,
No, whatever will be the reason,
yes,
now
sir.
you'll have to file an IA if you want a extension of the order. Mr. Roy, you want this item 19
19.
on
23rd.
23rd, okay. Okay, I'll have to rise because there's
But
a,
item 20, my lord,
the court master will get the dates.
already notice has to go, but there is a delay, my lord,
Item 20,
20, my lord. So, and lordship will take justice service, my lord, matter may be fixed after this, next week, my lord. Because there is
20,
execution pending.
Pondicherry Day. Notice steps by both ways, postal as well as
Justice service.
Dasti. No, postal also.
My lord.
So item number 15.
Dasti, we don't know to whom we will serve.
No, we'll serve it, my lord.
No, it's okay, but
File an affidavit, my lord.
no, it's okay. But we don't know
And maybe I will take the both the steps, my lord,
both,
but
both ways.
it may be taken on the next week, my lord, but there is the execution pending, my lord.
Okay. We'll issue notice, we'll pass
On
orders.
20th, my lord, my returnable, will file an affidavit also, my lord, will take steps.
On
On 25th, my lord,
25th, in 1 week.
1 week or 10 days, my lord.
That'll be better. Okay, make it 30.
But item number 12.
Oblige.
Interim order.
Okay, just a moment. There's one matter I cannot take up. Item 18, disciplinary matter before any other bench without one of, without me.
Now, if a date is fixed, that will be convenient for us to appear on that bench, Your Honor.
Make
If
it
possible.
Wednesday. The learned counsel for the appellant, respondent expresses some urgency, list on. Make it Wednesday. Item 12, yes.
There is an interim order, my lord.
As well as also item number 15.
Just a moment. Okay. But we can't continue interim order. You've done the justice service.
My lord, we have taken steps for justice service, my lord, but service is
No,
not.
steps is taken is very good, but have you returned it?
My lord, I served it, but the person could not be, my lord, traceable.
No,
in
but
the-
if
in the
you are,
house.
if you don't serve notice, how can there be an extension of interim order?
My lord, we have taken steps and we have served, my lord, but the person concerned, my lord, to whom it will be served, he is not available in the house, my lord. He is residing in a rented house. That is the difficulty.
No, those things we
So
don't know. Difficulties may be hundreds.
My lord,
But the fact is that if you don't serve notice, you can't have an extension of the interim order. It's a matrimonial dispute, right?
Matrimonial. We want transfer of this case, my lord, from here to Bongaigaon because the my lord.
But
wife
unless
is
you
inside.
serve, why should we extend?
But some accommodation, my lord, because we have taken steps with other, we try to.
No,
my
no,
lord,
taking of steps, you are telling us for the fourth time. We are not interested in taking of steps. Have you returned these steps? That's the requirement. If you don't return it, then
We have not returned, that's why, my lord, we seek, my lord, some more accommodation, my lord. Not accommodation.
no. For the accommodation, you take first steps by registered post and by usual process.
My lord,
You take it by tomorrow.
my lord.
As per the office for the learned counsel of the petitioner, as per the office note dated 16/7/2025, the report of the service is not returned. So accordingly, the petitioner is directed to take fresh steps within tomorrow is 19, within 19/7/2025 to take to serve notice on the respondent by way of by registered post with AD as well as by usual process. Also not usual process, said by Dasti. No, if you can't serve by Dasti, then
Justice is not possible, my lord, because my lord, the person concerned he is not traceable. That's why, my lord, but we tried, my lord, our people went there.
no, shade short. You see, we are extending time and taking a matter. Please tell us in a short way.
My lord. And,
You want to serve by Dasti or no?
No.
No, okay. Then usual process. Good stop. The notice is made returnable on so and so. Give a date out of 5 weeks. Next part, it is made clear that if steps are not taken within the time allowed, adverse orders may follow. Next para, interim order passed release is extended till the next date of listing. List on so and so. So if you don't take step by tomorrow, adverse orders would follow. All of this the court master will give because I have to attend a meeting and then we have the reference.
Item 15 interim may be continued.
Tell the court master.